All right. I'm here today with Professor Daniel Kobil of Capital University Law School. Professor Kobil is known nationally for his work in the area of clemency generally, and in particular, clemency in capital cases. He's written what I think many people would consider to be the seminal work on clemency, a piece that came out a bit ago in the Texas Law Review that's been widely cited, including by the US Supreme Court. He's not only written about clemency, he's been a participant actively in several cases in which clemency has been at issue. So thank you, Professor Kobil, for joining us.
Thank you, Jim. You are too kind, and it's a pleasure to be here.
Well, I want to tap your expertise in this area, starting basically. Can you just tell us what are the different forms of clemency in a capital case in particular, and the general purposes of clemency in the legal process?
Yeah, we use the term clemency as an umbrella term that refers to the various constituent types of remission of punishment that can be granted, typically by the executive, sometimes with the either recommendation or favorable decision of an administrative body. But clemency embraces the broadest form, which would be a pardon, which would be a complete forgiveness, release from prison of the individual. It's essentially a determination that the crime for which one was convicted did not occur, and it's usually deemed to be appropriate for people who are undeniably innocent. The more limited form of clemency and much more likely to be obtained in a death penalty case is a commutation, which is the substitution of a lesser punishment for a greater one. Typically, death row inmates seek remission or a commutation of their sentence from death to either life imprisonment or sometimes life imprisonment without parole. And then finally, the third type of clemency that is relevant is a reprieve, which is simply a postponement of punishment. And that's often given when there are difficulties carrying out the sentence, questions about the timing of the execution, and that's the most limited form. In Ohio, we've had a history of governors granting a series of reprieves as they have had a very difficult time getting the drugs to execute people.
Well, in this day and age, we have about 28 states and the federal jurisdiction who authorize capital punishment. And I assume, but you can correct me, that there are many different systems that are employed in these different jurisdictions. You said that in some, the governor has the exclusive authority, and in some, there's a board, and in some, they work in combination. Is that correct?
Yeah, that's exactly true, Jim. That every state has essentially its own discrete system of clemency. So as a practical matter, we have 51 systems in the United States. So it's very important for you to familiarize yourself with your state's own procedure, and there's a wide variation in how willing states are to use clemency, particularly in death penalty cases.
Right, and what about procedure? Many people may assume that there's a trial-like or a formal hearing that leads up to a decision of considerable magnitude, right? This is basically the last stage before somebody may be executed. So there's an awful lot on the line. What are the typical processes that are involved in a hearing or a consideration of a clemency petition?
Well, again, that is going to vary a great deal because the Supreme Court, actually in a case that I was involved in early on with the Ohio Public Defender's Office, a case called Woodard versus the Ohio Adult Parole Authority, the Supreme Court ruled that only minimal due process protections applied to the clemency process. So that was a very close vote. A number of the justices, four of the justices wanted to say due process did not apply at all. Justice O'Connor provided the deciding vote in favor of due process applying to the clemency procedure. And she said basically that an extremely arbitrary procedure like the toss of a coin would violate due process, but that states have a wide latitude. So some states are going to take their responsibility very seriously. They're going to give the applicant an opportunity for an application, followed often by an interview of the board or some part of the board with the inmate, followed by a formal hearing, often where evidence is provided to the board, followed by a recommendation to the governor, or in states like Georgia, where the board makes the decision on its own, they would then make the decision. So in a state like Texas, the board has to make a favorable recommendation in order for the governor then to grant clemency. So it takes two recommendations in that way. So again, the procedure is going to vary. I think the elements I've outlined are typical in a number of death penalty states.
All right. Now, just to set the stage here, the clemency is at the tail end of a process that would begin typically with a conviction for a form of aggravated murder, a jury that listens to mitigation, aggravation evidence, makes a decision that death is appropriate, multiple layers of judicial review, the execution date is approaching. What are the common themes that might be raised at this ultimate stage that are used as a request to spare my life? What might be a part of the substance of a typical clemency petition?
Yeah, that is something that I think lawyers often misapprehend, because you're right. The clemency decision comes after the courts have concluded their review in almost every instance, because governors and parole boards don't want to make a decision needlessly. So if it is possible that the states will resolve this in the courts, they'll let the courts handle it. So the kinds of arguments that you are making are often non-legal arguments in the sense that they're not based on cases. Attorneys want to cite cases as reasons for clemency, but the kinds of grounds that decision makers have cited have been things like disparities in punishment. So someone is sentenced to death, but the more culpable individual in the crime, who either was the trigger man or the mastermind, got life imprisonment. So a disparity in the punishment that's imposed is one possible ground for it. In a recent case that I've been involved in, I made an argument to the Ohio Parole Board that we were applying the death penalty in a systemically racist fashion. Not that any one case was necessarily marred by an equal protection violation, but the fact that 57% of the men on death row are Black, when we have a 12% African American population in Ohio, really suggests a systemic problem in implementing the death penalty. And it was a very difficult argument to make, but one parole board cited that in his favorable decision in favor of Mr. Lott, the recommendation to the governor. We're still waiting to hear on that one. So broader systemic arguments, including, of course, if there is evidence that hasn't been considered by the courts, claims of innocence, the typical things you would think of. I generally tend to say that clemency is a chance for someone with the power to do something about it, to look at the entire case, to look at the evidence that courts would not consider, to consider whether this as a whole is going to result in a more just legal system in a particular state or the federal system. So I see it as an opportunity to make systemic fairness arguments. This is not fair. This is not humane. Things that the courts typically would discard and not listen to.
So it's a very different and interesting shift in strategy from a strictly legal kind of an argument.
Yes, and I think lawyers make a decision, sometimes to try to pursue this like another level of appeal, and I think that can be a mistake.
Now, correct me if I'm wrong, but it seems that Ohio has been much more willing than many other states to grant clemency in capital cases. And maybe it's because you're sitting there in Columbus, being a part of this, but it seemed to me that a few governors, I think Celeste, Strickland, and Kasich, not just one governor, but they've been much more willing than the executive authority in other states to go this route. Is there a reason for this?
That was one of the arguments I made to the Ohio Parole Board. I said, Ohio takes clemency seriously. And you're absolutely right. If you compare the number of humanitarian clemency grants to the number of executions, it's close to a 2-to-1 ratio of executions to grants. So Ohio's had 56 executions and has had 21 clemency grants. So there have been a substantial number of people taken off death row through clemency. If you compare that to Texas, it's virtually nil. Texas has 574 executions and only 3 clemency grants. So clemency is almost never a realistic alternative. Why Ohio does this, I do think that at least historically, we've been ambivalent somewhat about the death penalty in our state, even among Republicans. Often some of the outspoken critics of the death penalty of Ohio have been Republican office holders who leave office and then see the light on that. I'm thinking specifically of our former Attorney General, Jim Petro, or former Governor Bob Taft. They're both, been critics of how the death penalty is applied in our state.
Well, that's obviously this is partly a political decision. The politics from a state like Texas versus Ohio are going to be considerably different. Let me ask you one last question before I let you go. Thinking back on kind of watershed moments in the modern era of the death penalty, I think we could agree that when Governor Ryan in Illinois made the blanket commutation of Illinois death sentences, it made a lot of people take notice and shifted to some extent public opinion. If you had a crystal ball, can you imagine any comparable act occurring in the future of a broad scale kind of a decision to commute death sentences?
I certainly could imagine it. It's something I was there at the announcement of Ryan's commutations of death row, and got to chat briefly with him, and he essentially said, if I, as a pharmacist, got it wrong as much as the legal system did, I'd be in jail for that. He later did go to jail, but for other types of things. But that was not for anything he did as a pharmacist, but or for anything he did with commutations. And in fact, I'm wondering whether our current governor, Governor DeWine, is laying the groundwork for something akin to that, maybe not as dramatic, but he has recently told the legislature, we cannot execute people in Ohio using the lethal injection method. You're either going to have to come up with something different and less palatable to many, is sort of the unspoken thought on that, or we're not going to be able to execute anybody. He's also gone on record as saying, I'm not sure that there's any deterrence value to the death penalty anymore. And that is what he believes is the only moral authority for having a death penalty. So having a middle of the road Republican like DeWine make that kind of a statement to a legislature that has also expressed skepticism, a number of the Republicans in the General Assembly have talked about whether we should have a death penalty, suggests to me that it's at least conceivable that we might look forward to something dramatic in Ohio one day.
Well, we will see what we will see. Professor Kobil, thank you so much for your support of the National Death Penalty Archive. Again, some of the petitions you've worked on have found their way there. And thank you so much for your work in this area.
Well, thank you, Jim. And let me just put in a plug for those petitions. Go look at them. They're electronically available, and they really give you an idea of the different kind of arguments that can be made in a clemency case that are really not open to us as lawyers when we're in the courts. So I think what you're doing is tremendously important, Jim, and thanks for the chance to talk to you.